Welcome back to Organized, and we're talking about mastering limited liability companies. I'm Professor Seth C. Oranburg, and this is episode 6. We're going to shine a spotlight on veil piercing in the LLC context. We'll talk about veil piercing on its own separately, but in the LLC context, there's a few special things to know, and this is a critical topic for both lawyers and business owners, because you might assume that a limited liability company limits your liability, keeps your personal assets safe. We'll see that Uniform Limited Liability Company Act Section 304 generally does bar personal liability, but that shield can be pierced in a number of real-world conditions. So let's dive in. At the core of every LLC is limited liability, the principle that members or managers aren't personally on the hook for the entity's debts or lawsuits. And as I mentioned, this is under ULLCA Section 304. If an LLC fails to pay a vendor, the vendor can't seize the member's personal bank account or take their car, absent these extraordinary circumstances like personal guarantees or fraud, or in some cases, veil piercing. The protection mirrors the corporate veil that shields corporate shareholders. However, the shield is not absolute. Courts will sometimes pierce the veil, holding a member or manager personally liable if they use the LLC to commit a fraud, undercapitalized it deliberately, or treated it as a mere extension of themselves. In that sense, LLCs share a fundamental parallel with corporations. Both can be pierced if the owners fail to maintain a genuine separation between the personal affairs and the business affairs. So, how does this actually manifest? Although the underlying rationale for piercing across entity types is similar, there can be notable differences because there are differences in formalities and structure. So how does this manifest in LLCs in particular? Let's talk about formalities first. Traditional corporate law expects a great deal of formalities, like issuing stock certificates, holding annual meetings, adopting bylaws, electing directors. Failing those can weigh in favor of veil piercing. LLCs don't have all of these required formalities. The statutory formalities are pretty minimal. Merely not holding an annual meeting is typically not fatal in the LLC context. But if you completely disregard even the LLC's few basic steps, that's a factor that risks a court viewing that LLC as an alter ego of the person who disregarded it. Basically, if you don't treat it like a separate company, you treat it like yourself in the sense that you benefit from it, society is less willing to give you protection of limited liability. And this is particularly true in single-member LLCs. Similarly to single shareholder corporations, courts might pay close attention to whether a single-member LLC commingles funds or use corporate assets for personal expenses. In a single-member LLC, these vulnerabilities are greater if the sole member doesn't have a separate business account or signs contracts in his or her own name, or doesn't pay attention to the operating agreement, or doesn't have one. So a few recommendations to avoid veil piercing in single-member LLCs are the converse. Open a separate bank account. When you sign the contract for the LLC, write member or owner or manager. Sign it in the business name and not in your personal name. And maintain an operating agreement. Even if it seems silly to have a contract with yourself, that mere formality suggests you're taking the LLC form seriously. The corporate law around piercing is somewhat phrased in circular terms, like they'll use an alter ego test or an instrumentality test, meaning if the corporation is merely an alter ego, then it's justified to pierce it. And you can probably see how there's a bit of tautology there. What we're looking for in these tests generally is some element of wrongdoing and a failure to treat the corporate form or the LLC form as a serious separate entity. If you don't treat your own LLC as separate from yourself, why should the rest of society? Courts will basically use the same language and recite this alter ego and instrumentality language, but they tend to apply it more flexibly because LLCs have fewer formalities to uphold. This can help owners or hurt them because since you don't have a lot of formalities that you have to follow, there aren't a lot of failures for merely failing formalities. On the other hand, it can hurt single-member scenarios in particular when they appear sham-like because there isn't any evidence the judge can point to that shows that they ran this business like a real company. The bottom line is that LLC owners shouldn't assume they're safer from veil piercing than corporate shareholders. Courts really look at them the same kind of way. And it might even be more risky because we don't have as much case law on limited liability company piercing just because they're newer. And you might be in a jurisdiction that doesn't have as robust a case law as Delaware does with corporations. Let's talk about a famous case. This is the case of Casey Land and Livestock versus Flahive out of Wyoming, and it's often cited in LLC scholarship. Flahive's single-member LLC faced claims that it had effectively no separate existence from its owner, and here's the evidence. He commingled funds from the LLC and his personal accounts. He didn't have a separate bank account. He didn't follow any formal process aside from filing. The court recognized that yes, LLCs can be distinct entities, but they remain vulnerable to veil piercing if a plaintiff can prove it's a mere alter ego or if there's fraud or injustice. So a few key points. There are no built-in formalities to single-member LLCs, so there's a lack of natural checks and balances. This means that instead of following a rote playbook of ways to maintain separateness, you have to act reasonably, like by keeping robust financial records or having a separate bank account and not spending corporate funds or LLC funds for your own benefit. Undercapitalization is another major source of piercing, as we talked about with corporations. If you launch a business with $1 in its bank account, no insurance, and no operating agreement, yet you undertake risky operations, that signals you never intended to bear the normal responsibilities of a legitimate enterprise, and that would be an invitation for veil piercing. Again, we can think back to some of our corporate cases, like Walkowski versus Carlton, where a person was injured by a cab and wanted to pierce the corporate veil to get at the cab company's other holdings. Now, in that case, the cab company had maintained the statutory minimum amount of insurance, and that was enough in that case to block the veil piercing. But if you had an LLC and you drive around in New York City hitting people with $1 in your bank account and no insurance, you should expect to be personally liable, even if you're doing that as an Uber driver or a taxi company. And finally, in comparison to the corporation, the key takeaway is that in corporations we have set formalities that we have to follow. And it's not the case that you don't have to follow any formalities in LLCs. It's just very flexible. So we're going to apply a flexible standard and ask, did the LLC owner act as if the company is a separate entity? And we'll look at a multi-factor test based on facts and circumstances. Again, key concept, maintain a separate bank account, sign things in the LLC's name, maintain insurance if you're going to take on a risky business, have an operating agreement, follow the operating agreement, maintain books and records. These are the sort of things that when you treat an LLC like a separate entity, the courts will too. Let's take a look at another situation. We've already discussed what happens if the LLC has debts. But what if a member has personal debts? Suppose someone, let's call her Alice, owns part of an LLC and personally, because of a debt she took out, personally owes money to a creditor, say Bob. But Alice won't or can't pay Bob. And again, Alice's debt to Bob is personal. Maybe she hired Bob to repair her front porch and didn't pay him for it. Bob can't just take Alice's share of the LLC, but there are instances where Bob can ask a court for what's called a charging order. And a charging order can actually give Bob access to some of Alice's assets in the form of her company because of her inability to pay her personal debt. A charging order would redirect Alice's share of distributions from Alice to Bob. So the LLC, when it pays out its members, instead of paying Alice, could be required by a court to pay Bob because Alice has personal debts to Bob. But the peculiar case of a charging order is not the same as someone actually giving up that asset or that unit ownership. It's not like Alice has to give her share of stock in a company to Bob in order to pay the debts. She only has to assign the benefits of being that member and only the financial benefits. Remember that LLCs are flexible and we can sort of take them apart, pull different levers. You can have financial interests or governance interests or interest in losses instead of profits. In any event, In the case that Alice owes Bob some money and Bob gets a charging order that gives him a right to the LLC, Bob's right is only to the LLC's distributions and only if they make distributions. Why would this be? The purpose of a charging order, which is under ULLCA Section 503, by the way, is to protect the other LLC members. They don't have to deal with Alice's creditor as a new business partner, and they don't have to risk a forced liquidation of the business just because one member was not careful in her own financial affairs, while at the same time giving the creditor some recourse, but not control of the business. And so, if an LLC is legitimate, but a member has personal debts under ULLCA Section 503, a creditor cannot seize the member's interest outright, but rather can ask for a charging order and can gain the rights to receive distributions the member would otherwise get. I'll give you an analogy and a distinction. So this is similar to having a lien on someone's wages. So if you can't pay your debts, sometimes a court will order that your employer has to issue the paycheck to the creditor instead of to the debtor. And this is similar, like an LLC is sort of like the employer in this case, and when it issues distributions, those distributions go to the creditor and not the debtor. And we contrast this, we distinguish it from corporations, because in corporations, the debtor might have assets, including shares of stock, and we could effectively force the debtor to hand over assets to satisfy the creditor, which could include the transfer of those actual shares of stock. When you transfer a share of stock, you transfer all the bundle of rights that comes with it, which would include your voting rights. But an LLC is designed differently, and this is a little bit more like a partnership situation where we don't just want a random person walking in and having the ability to control the business. Yet having said that and mentioned the partnership reference, we once again have the special case of single-member LLCs. Some states treat single-member LLCs differently because we don't have the same issue about the potential for disrupting the business operations with the other partners. In the case of a single-member LLC, some courts in some states will effectively allow the creditor to take the LLC instead of the debt that was owed. But again, this is another special case. The third special case is a series LLC. If you're in a series LLC jurisdiction, a charging order might attach only to the specific series that the debtor owns. That's an advanced scenario that we'll talk about when we get to some advanced frontiers. So, how do you avoid veil piercing and other creditor nightmares in an LLC context? 1. Maintain separate bank accounts. Never pay personal expenses from your LLC's checking account. And if for some reason you had to, you should document it, transfer the money back immediately. Keep records. Label transactions properly. For single-member LLCs, this is especially crucial. 2. Adopt and maintain and update an operating agreement. Even if you're the sole member, even if making a contract with yourself seems silly, have a short written agreement laying out your LLC's purpose, basic capital structure, and decision protocols. 3. Maintain adequate capitalization and insurance. Businesses might be inherently risky. If you deal with hazardous materials or you drive cabs in New York City, you have to have funds and self-insure or have real insurance at levels that you show you take personal liabilities seriously. Courts look askance at shell entities set up to dodge accountability. And 4, respect creditor protections. If a creditor obtains a charging order against a member's interests, complying with the court order means redistributing distributions to that creditor, but it doesn't mean that the creditor gets to vote in the LLC's business. Trying to circumvent that in some way, like ceasing to make distributions when you had before in order to avoid paying the creditor, itself might trigger allegations of fraudulent transfer or veil piercing. This wraps up our look at veil piercing and creditor rights under the Uniform Limited Liability Company Act. So remember, while Section 304 grants a robust liability shield, ignoring basic separation or using an undercapitalized sham LLC will certainly invite a court to pierce the veil, leaving personal assets unprotected. Meanwhile, creditors dealing with a legitimate LLC must rely on charging orders to satisfy a debtor member's obligations, unless in some special cases when we're talking about a single member scenario. then there are special rules. Ultimately, this is a balancing act. LLC owners enjoy limited liability, but must demonstrate genuine independence from personal finances and business finances. Next time in episode 7, we'll move on to disassociation, dissolution, and deadlock, triple Ds of how an LLC dies, covering how members exit an LLC, or how the entity winds up operations when things go sour or when we're done with the project. We'll examine ULLCA Section 601 and 701 and read cases like Fisk Ventures. Until then, I'm Professor Seth C. Oranburg, and you've been listening to Mastering LLCs. I'll see you next time for more insights on limited liability company management.